In one of its most anticipated legal decisions this year, the U.S. Supreme Court has ruled closely held corporations can claim a religious exemption to providing contraceptive coverage under the Affordable Care Act. The case of Burwell versus Hobby Lobby concerned a requirement of the president's health care law that businesses with more than 50 employees must offer health insurance or pay a penalty. All FDA-approved contraception must be included in that coverage. Hobby Lobby President Steve Green objected on religious grounds to providing 4 of those contraceptives, 2 forms of emergency contraceptives and 2 forms of IUDs.
This is an issue of life. That we cannot be a part of taking life. And so to be in a situation where our government is telling us that we have to be is incredible.
Hobby Lobby, along with one other company, sued then Secretary of Health and Human Services Kathleen Sebelius, claiming the contraception mandate was a, quote, substantial burden on their religious expression. At the heart of this case was the concept of corporate personhood. That is, whether corporations share an individual's right to religious freedom, and if so, could they refuse to comply with the Affordable Care Act's contraception mandate based on those beliefs? The court's 5 Republican-appointed justices said they could. Writing for the majority, Justice Samuel Alito said under current law, enforcement of the contraceptive mandate against the objecting parties in these cases is unlawful. Also Monday, in a blow to unions, the Supreme Court handed down a narrow ruling in Harris versus Quinn, saying home caregivers cannot be forced to pay union dues. For Newsy, I'm Elizabeth Hagedorn, multiple sources, a broader view.